The numbers are not complicated, but they are uncomfortable, and they are worth setting out slowly and in order. If you live in India or Pakistan, you have an opinion about your criminal law. It is probably older than your country. The code that defines murder, theft, and sedition across both was drafted in the 1830s by a committee in Calcutta for a population that had no vote in it. India used it, almost unchanged, until the 1st of July 2024. Pakistan uses it today. So does Bangladesh. Now here is the part that surprised us, and it is the reason to make this episode. The man everyone blames did not write the sections you are angry about. Sedition was added 10 years after he died, and the harshest versions of these laws were not written by the empire at all. They were written after independence by governments answerable to their own people. This is the Indian Penal Code, audited, including the parts where our own side is wrong. The numbers are not complicated, but they are uncomfortable, and they are worth setting out slowly and in order. Thomas Babington Macaulay arrived in India in 1834 and chaired the first law commission. The draft code went to government in 1837. He was explicit about who a code was for. In the House of Commons, quote, "A code is almost the only blessing, perhaps is the only blessing, which absolute governments are better fitted to confer on a nation than popular governments." Read that again. Not a blessing of representative government, a blessing an absolute government is better at giving. He is telling you the code works precisely because nobody it applies to gets a say. And on the people themselves, from his minute on education a year earlier, quote, "We must at present do our best to form a class who may be interpreters between us and the millions whom we govern, a class of persons Indian in blood and color, but English in tastes, in opinions, in morals, and in intellect." We should be careful here, because this channel gets accused of stretching. That line is about education, not criminal law. It tells you how he saw the people. It is not the code's preamble. Now the correction almost nobody makes. It was not one man. There were 5 commissioners. And the code that actually became law in 1860, 23 years after the draft and a year after Macaulay died, had been substantially reworked by Barnes Peacock. Fitzjames Stephen said parts of it could never have come from Macaulay's pen. The numbers are not complicated, but they are uncomfortable, and they are worth setting out slowly and in order. Sedition, Section 124A, the most notorious provision in the Code. It is not in the 1860 original. It was inserted in 1870 and rewritten in 1898. Macaulay had been dead for 11 years. Section 377, the provision used against gay people for a century and a half, is not his drafting, either in the form that was enacted. So the 2 sections that carry the most anger in both countries were added by later colonial administrators to a document he had left behind. And there is something else in his own hand that complicates the villain story. Writing to his father from Calcutta in October 1836, quote, "We have got rid of the punishment of death, except in the case of aggravated treason and willful murder." At a time when English law still hanged people for a long list of offenses, the code he drafted cut capital punishment to 2. That is not a small thing, and we are not going to pretend it is. The numbers are not complicated, but they are uncomfortable, and they are worth setting out slowly and in order. 1897, Bal Gangadhar Tilak is prosecuted under 124A. Then, in 1922, Gandhi. In court in Ahmedabad, Gandhi did not defend himself. He pleaded guilty and then explained the section to the judge, quote, "Section 124A, under which I am happily charged, is perhaps the prince among the political sections of the Indian Penal Code designed to suppress the liberty of the citizen. Affection cannot be manufactured or regulated by law. If one has no affection for a person or system, one should be free to give the fullest expression to his disaffection, so long as he does not contemplate, promote, or incite to violence." He got 6 years. Hold that sentence, because the next act is about what happened to that section after the people who were prosecuted under it took power. The numbers are not complicated, but they are uncomfortable, and they are worth setting out slowly and in order. Both new states inherited the code in 1947. Neither threw it out. India kept the Indian Penal Code, unchanged in its bones, for 77 more years. In 2022, the Supreme Court put sedition prosecutions in abeyance for pending trials, which is not the same as striking it down, and the matter now waits on a larger bench. On the 1st of July 2024, the code was replaced by the Bharatiya Nyaya Sanhita. Much of it is renumbering, and the successor provision to sedition, Section 152, raises the maximum sentence from 3 years to 7. Read that carefully. The colonial section allowed 3. The independent republic's replacement allows 7. Pakistan kept the same code under a new name, the Pakistan Penal Code. In 1980, Section 377 acquired a 2-year minimum sentence it never had under the British. In March 2023, the Lahore High Court called sedition, quote, a relic of autocracies and colonial subjugation, and struck it down. That judgment binds Punjab. It is under intra-court appeal, and prosecutions have continued elsewhere. So the honest scoreline is this. The Empire wrote the section. Both successor states kept it. One of them has now made it harsher, and the other has struck it down in one province while arguing about it in the rest. The numbers are not complicated, but they are uncomfortable, and they are worth setting out slowly and in order. We owe the other side a hearing, and it is stronger than you would like. Stephen, in 1883, quote, the Indian Penal Code may be described as the criminal law of England, freed from all technicalities and superfluities, systematically arranged and modified in some few particulars. They are surprisingly few, to suit the circumstances of British India. English criminal law at the time was a thicket of overlapping statutes and case law that ordinary people could not read. The code was clear, ordered, and could be looked up. It abolished most capital offenses. Serious legal historians treat it as a genuine achievement, and India and Pakistan did not keep it for a century and a half only out of inertia. It worked. Both things are true. It was a real piece of legal craft, and it was written for people who had no say in it. The numbers are not complicated, but they are uncomfortable, and they are worth setting out slowly and in order. One last audit, and this one is on us. There is a speech that circulates constantly, said to be Macaulay addressing the British Parliament in 1835, describing India's spiritual wealth and vowing to break its backbone. It is fabricated. Parliament was not sitting, he was in Calcutta. It is in no record of the House. The portrait attached to it is not even him, and the identical text circulates elsewhere with the word Africa swapped in. We mention it because a channel that audits everyone has to audit the things its own audience forwards. The real quotes are worse than the fake one, and they are sourced. So, not one man, not his worst sections. A code drafted for a people who had no vote in it, kept by 2 states that did, and made harsher by at least one of them. The Empire wrote the law, the republics renewed the lease. Tareekh ka Hisaab, history audited, Hisaab abhi baki hai.